promise to answer all the questions that maybe asked. But let me just try to summarize in one word what this opinion really means. No, it is. No, this is what's going on. We know that I've talked about this, and trying to make the point of how just patently troubling it has been for patients and caregivers with the lacking of honest interpretation of the Michigan Medical Marijuana Act. And I'm not talking anything different, just reading the words and giving them the meaning that they're given in the everyday understanding in the world. And I say that because we know and understand the idea of the limitations that a patient or caregiver are allowed to possess. And it's very, very specific in that there's a volume limitation. And it took some time to even come up with the idea of what a volume limitation was. It refers to the maximum quantity allowed for a patient or caregiver to possess pursuant to the Michigan Medical Marijuana Act and maintain their immunity. There's other conditions with it as well, but speaking to the volume limitation, the amount, which was originally only a category of plant-like material without any other explicit references or identifying any other types of marijuana. That was problematic. You wouldn't think it would be, but it was problematic because there's nothing specifically referenced. And from that, I take that back. That's not what I would say. There wasn't anything specific referenced. There was mixtures thereof, which was defined within what usable marijuana was, or if it's not plant material, it would be mixture thereof or preparation. And so these are the things that one would conclude are the non-plant material. Mixtures of cannabis, THC, some of the extract of the plant with some kind of food product or baking, and then, of course, the preparation there would be some kind of extraction of the oil or whatnot. That's the way that I always thought it, but whatever. Doesn't matter what I thought. But they came out with this opinion, which has been, the Brownie case, Earl Carruthers, who we're now representing, and have just been called back to the Honorable Judge Warren. We're going to be dealing with that case. Yeah, you'd think, what is going on? Right.
I thought it was done.
We can talk about that. That's a good one. Put that finish. Anyways, but the significance of Carruthers is pretty interesting as it relates to what's going on here, because we all understand that Carruthers is a terrible, terrible opinion. Terrible. It is hard to read. It's hard to understand. And while I may not be quoting it exactly, something to the effect was one of the statements made by the justices in their wisdom, where they said something to the effect of the unmeasurable but highly potent marijuana brownies. How can something be highly potent if it's unmeasurable? I mean, it just right there in plain English expressing their lack of knowledge of any of this. So, but it was a terrible opinion for a lot of reasons, and what happened in that opinion was they determined that the brownies didn't fall in the category of usable marijuana. And I have a problem with that, because I thought that there was a category within usable marijuana was defined, could be possessed, and they did not find that those categories covered marijuana brownies, and they did everything they could to find a way not to just read the statute and apply mixture or preparation thereof, and went out of their way to try to find and deem these things unusable. And then went as far as to, in one of the greatest moments of judicial activism, these so-called Federalists, judicial activism, created an element in the statute that doesn't exist, called unusable marijuana is illegal. This is what they came up with. It's judicial activism at its greatest. They created an element from the Carruthers case. And the reason they created an element is because brownies, they said, were not within the definition, fell outside of it into this other category, which is unusable or reverts back to the public health code and the definition of marijuana. It's hard to even comprehend. Nevertheless, this opinion exists, and it's terrible, and Earl Carruthers we're still fighting the case. I'll maybe talk about that after the break. Anyways, so What happened since then? Well, the legislature sits down and writes a law, 4210, Amendment 2016 went into effect in December 2016, but not just in effect at that time. It went into effect and then was immediately retroactive back to day one of the Michigan Medical Marijuana Act. It was a law it was an amendment to the existing Michigan Medical Marijuana Act that was retroactive. Ask any lawyer you know how many amendments to a statute they know of that apply retroactively, or a statute that's enacted and applies retroactively. I don't know of one in the last 25 years. And in addition to it explicitly stating that, the legislature stated the intent of us doing this is to fix or cure the problems that have existed and their utter failure to be able to protect patients and caregivers, as was their task as enumerated within the Michigan Medical Marijuana Act. Specifically, paragraph 2 of the preamble, which to some degree says, by enacting this law, it will greatly reduce the number of arrests for sick people. And they know that the statistics don't support that. We got an increase in arrests 14% since the enactment of marijuana charges. Wasn't supposed to happen. And we have a forfeiture that is still running out of control and can only be defined by the most greedy, out of control, desperate set of individuals that and just abusing the system for their own greed. But putting all that aside, the legislature realized they had failed, and they wrote these amendments for that specific purpose. And I would even argue to obliterate the crap that came out of the Court of Appeals in the Carruthers opinion. To say, no, that which you call unusable cannot be. This law was not enacted, and if anyone thought that it was enacted and intended to be a medical marijuana act that required patients to smoke marijuana only, including children, and that's your sadistic interpretation, Court of Appeals, fine. The legislature stepped up and did the right thing. They amended the law and opened a whole new category of usable marijuana. Excuse me. Marijuana-infused products, different volume limitations, and really expanded by explicit intention protections for patients so that they would not be arrested. Now, with that being said, and the taking away the prohibition that non-plant material could not be possessed by this legislative enactment, for some odd and strange reason, there was really no other action that had been done by the legislature to try to fix some of the other fundamental problems that were contributing to the increase in arrests since 2008 instead of decreasing the arrests. And I'm specifically talking about the issues surrounding wet or drying marijuana. Now, if I had to put 3 categories of types of cases that traditionally become felonies regarding medical marijuana, it would be the following. One would be, and for whatever reasons, I mean, there's different reasons why they may stumble upon or get a tip or what have you, but they usually involve issues regarding cultivating marijuana where there's not an enclosed locked facility, or there's a dispute about the number of plants, dead, dying, clones, whatever. Something silly and really and kind of de minimis to its intention, especially when it's an issue of an enclosed locked facility and within the facility is compliance and volume limitation compliance. That's one of them. The other one would be the different types of deliveries, right? We know that there's caregivers the limitation per however we can title is there's 5, and that is who you get immunity for. That's that case. Anyways, they've set forth the Section 8, Section 4 limitations, and at the end of the day, the immunity, it's McQueen, immunity only applies to the delivery of marijuana to the connected patient for the caregiver. Patients can acquire from anyone. So that's how that's been resolved, and while there's still a dispute whether that transfer of the sick patient can be defended under Section 8 or not, we know that. But the third category, which has not ever been addressed, is the issue of usable marijuana versus, which is the dried leaf of the plant, not to include the stalks and stems, etc. And because of these third category of cases we see in our office, it's where people have harvested 3 of their 12 plants, or they have an outdoor grow and it's 72 plants, and they take them all down and around the same time, and it inevitably creates this circumstance where they're going to have wet marijuana, and the only way they can genuinely stay in compliance is to control and take control of the plant material's usability and when it's going to be usable, and to keep it in a state of not yet cured and ready for use as their only real method to defend themselves. Not to mention all of the processes that take place and the variations of getting to the end game of producing dried, cured medicinal cannabis, which is an elaborate process. What someone has to go through, and all of the trimmings and cuttings and discarded material that would be part of that to get to that particular point. And I don't think that knowing that this law was passed with the intention to protect people, I don't know that there's a reasonable way to interpret the law to suggest that the limitation is to not possess more than 2.5 ounces of marijuana. And if you have that, the law, I would argue, suggests that any other related to that, as long as it's not usable, is not an amount that is counted. Now, I say that, and that's the reading. And I learned early on from some other ways that the ball bounces, especially about medical marijuana, that despite the clear reading of it, you've got a sadistic court of appeals that will destroy, and the only way to destroy what would be rational. And it's happened over and over and over again. Over and over and over again. We've been fortunate that the Michigan Supreme Court, most of the time in unanimous opinions, has set that the Court of Appeals straight in their terrible opinions time and time again. And I would say we're fortunate because the Supreme Court salvaged Section 8, which was being decimated by the Court of Appeals, put some reason and logic into the procedures for Section 8 and Section 4, which, if left to the Court of Appeals, would have been just a disaster. But these are things that are all taking place without any kind of clarity on this issue of usable marijuana. If I told you the number of times these issues came up and people were destroyed, that they found themselves outside of the immunity. They did not go into this to be called a felon and charged with 5 to 45 kilograms of marijuana, 7-year or 15-year felonies. It's part of the process of caregiving. They let me grow 12 plants, one would say, and I took 6 down, and I got a 9-pound case because they included the stalk and the wet leaves. All right, so this has been going on. And I would mention along the way, many who are in this room may recall that the first go-around, I think it was 2011, taking testimony to the Judiciary Committee of the House. Ken Stecker gave an opening statement. Does anyone remember what I'm talking about? Okay. And at some point in time, and Representative Horn was on it, and Walsh, and Kavanaugh. Was Irwin? I don't know who Irwin was. Yep. The first time? All right. Nevertheless, they were not the hard ones, right? It was everybody else who were trying to, get it. Mm-hmm. But nevertheless, the guy, Horn, Horn from from Frankenmuth. Ken Horn. We were just talking to Frankenmuth. Asked, I remember this so explicitly. There was a representative of the state police giving their testimony on the MMA state of affairs, the second day, I think. And he said, Michigan State Police representative, in light of the definition of usable marijuana in the MMA, what is the position of the Michigan State Police? And they said, we don't have one. Now, this is a fascinating moment in the history of the MMA, because had they given some guidance at that moment, people would have had knowledge. They would have known what to do. They know what they read it as. Why keep it a secret? What is your interpretation of those words regarding usable marijuana, so people know how you're going to play it if they should have an encounter with you? And their response was, we don't have one. So from 2011, 2012, 2013, 14, 15, 16, the state of affairs regarding usable marijuana was in the total discretion of the officer